In the dead of the night, a legal battle is brewing. Two courts, two different rulings, one gun law. And the Supreme Court is being summoned to break the curse of conflicting law. Welcome to spooky season in Hawaii, guys. This is your daily Second Amendment news. I'm Gun Gnome, and today we're going to dive into the vampire rule, also known as Wohlford versus Lopez. This case has been haunting the circuit split, and guys, it's going to be the next big win for gun owners. Why don't you hit that subscribe button if you're tired of the government haunting your gun rights? So here's the deal with Wohlford versus Lopez. In the state of Hawaii, it is a given that any place is a gun-free zone unless you are specifically told by the owner personally that you can carry there. We're talking private property that is used for public spaces here. And that's what's known as the vampire rule, meaning you have to have a connection to somebody in order to carry there. Now, this originally started in a state called New York. Big surprise, right? And in New York, they had this same law. Well, it went to the Second Circuit Court of Appeals, and it was shot down and told, no, this is unconstitutional. Well, guys, the Ninth Circuit that Hawaii falls under said that this is constitutional. Now the Supreme Court has to step in on a gun law. This kind of split is a legal red flag for the Supreme Court. When two federal appellate courts disagree on a constitutional question, like whether or not large-capacity magazine bans violate the Second Amendment, the High Court often steps in to unify the law nationwide. It's like a multiverse of madness for gun owners. And the justices, they're like sorcerers who have to fix it. And haunting both of these cases is the spirit of Bruen, New York versus Bruen, where you have to apply text, history, and tradition to any gun law, future, past, or present. If the gun law does not align with the views and laws of 1791 when the Founding Fathers ratified the Second Amendment, then it should automatically be null and void once it goes through the court system. So in simple terms, if this law doesn't have a twin going from 1791 to 1868, then it's probably unconstitutional, but I don't have to tell you that. This gives Wohlford versus Lopez a real shot of winning in our favor, guys. Unlike other cases where we were checking every Monday to see if the Supreme Court was going to take it on, this fell under miscellaneous. So they had to take it on even though they don't want to. So if you live in a state that has any kind of vampire rule like this, guys, this is going to be a big win for your state and for all 50 states because the Supreme Court decides the law for the whole nation. And we're going to be watching this one like a hawk, or maybe a bat since it's Halloween. I'll be tracking this case like it's Freddy Krueger in a dream, so if you guys want to keep up to date with daily Second Amendment news at a county, state, or federal level, make sure you hit that subscribe button. Until next time, stay armed, stay informed, and maybe keep a flashlight nearby, because it's going to be extra dark for anti-gunners this October.